हेलो एवरीबॉडी। आज के इस वीडियो में हम रिलेशंस ऑफ पार्टनर्स टू वन अनदर के चैप्टर के कुछ प्रोविजंस के बारे में चर्चा करेंगे। इन अनदर वीडियो वी हैड डिस्कस्ड सेक्शन 9 to section 12. Now in this video we will be discussing the remaining sections of this chapter. Section 13 of the Act provides for mutual rights and liabilities subject to contract. These provisions are subject to contract. The opening lines are subject to contract between the partners. It means the rights and liabilities which are enumerated here, these can be varied by the partners through a contract, through an agreement between them. But of course that agreement has to be in consonance with the provisions of the Contract Act and the provisions of this Act also. But then what are the mutual rights and liabilities? So clause A says that partner shall not be entitled for any remuneration for taking part in conduct of business. No remuneration will be demanded by the partner. Share equally in the profits earned, contribute equally to losses sustained. Though here the words equally are used, but in fact the sharing of profit and contributing to loss, sharing of profit has to be in consonance with the capital or share of the partner, we can say, and losses also incurred by the firm. These have to be shared equally in proportion to the liabilities as per the share. But this is besides any loss for which the partner is liable for his act of fraud, willful neglect, whatever it is. And if any partner has subscribed capital which is in excess to his share and he is entitled to interest on that capital, then that interest has to be paid only out of profits, not out of the, that is a charge on the profits only, not on any asset or property of the firm. And if a partner makes payment or advance beyond capital for purposes of business, then he is entitled to interest at the rate of 6% per annum. Interestingly, clause E provides for the firm to indemnify a partner. It relates to the firm. Firm means the collective individuals. Firm shall indemnify a partner in respect of payments made and liabilities incurred in ordinary and proper conduct of business, and in doing such act in emergency for purpose of protecting the firm from any loss. So the first thing is, if any payment has been made or any liability has been incurred in an emergency to protect the firm from losses. And in what circumstances? As would have been done by a person of ordinary prudence in his own case under similar circumstances. So the yardstick is the prudence, ordinary prudence of a person who would have taken such steps, who would have incurred such liability in his own case under similar circumstances. So if that part is proved, that the act done by the partner is as would have been done by a person of ordinary prudence in his own case and under similar circumstances, then the firm is liable to indemnify that partner for the liabilities and the payments made. Clause F we have already discussed in another video, but we will throw some light here. A partner shall indemnify the firm for any loss caused to it by his willful neglect in the conduct of the business of the firm. So if a partner he indulges in willful neglect, then also he will indemnify the firm for the loss. But all these clauses are subject to contract between the partners, meaning thereby that this can be altered, this can be varied by the partners. Similar to this clause, section 10, which provides that partner shall indemnify the firm for the loss caused to it by his fraud. Similarly here, subject to the contract, for willful neglect also, the partner is liable to indemnify the firm for the loss caused to it. Then how the property shall be managed, or what shall be the property of the firm. One interesting and important point will come across here. Again, the opening line is subject to the contract between the partners. The property of the firm includes all property and rights and interests in property originally brought into the stock of the firm, which were included or brought into the stock of the firm at the time of launching of the partnership firm. All property, rights and interests, whatever in property, or acquired by purchase or otherwise. Otherwise it can be somebody has provided on lease, or the property has been taken on lease, or somebody has gifted, like that, by or for the firm. If the acquisition is by the firm or for the firm, or for the purposes of the firm and in the course of the business of the firm. In all these circumstances, if any acquisition of property is done, that property shall also be the property of the firm. And lastly, important point, and includes also the goodwill of the business. So goodwill, unless the contrary intention appears, property and rights and interest in property acquired with money belonging to the firm are deemed to have been acquired for the firm. Here the provisions make it clear, until and unless the actions they hint at some contrary intention, property and rights and interest in property acquired with money belonging to the firm, if the money belonging to the firm has been spent in acquiring the property and rights and interest in property, then these shall belong, that these shall be deemed to have been acquired for the firm. And goodwill of the business, as we find that it is also included in the property of the firm. Goodwill, we all understand, is a tangible asset. It is reflected in profits, reputation of the firm, leading to better earnings, like that. So that is also an asset with the property, and it is goodwill is also purchased and sold. Section 15. Application of the property of the firm subject to contract. Property shall be held and used by the partners for the purposes of the business. That is the purpose. Then section 16 if it provides that even the conduct of the business, a partner acts diligently and in a manner that he happens to earn some profit for himself, or if a partner carries on the same business of the same nature as and competing with that of the firm, and he earns money, he earns profit, then in both the cases he shall account for the profit and pay it to the firm. So personal gains, even we have seen that the partner is not entitled to remuneration for the work done for the conduct of the business. But these all are subject to contract. So the contract between the partners that emerges to be the main instrument which will govern the rights and liabilities. Of course, it should be in consonance with the provisions of the Partnership Act as well as the Indian Contract Act. Section 16 provides, if a partner derives any profit for himself from any transaction of the firm or from use of property or business connection of firm or firm name, he shall account for that profit and pay it to the firm. And clause B says, if a partner carries on any business of the same nature as and competing with that of the firm, he shall account for and pay to the firm all profits made by him in that business. Not from that business, made by him in that business. And the last section is section 17. It throws light on the rights and duties of partners when there are changes in the firm. Clause A says, after a change in the firm, when the firm is reconstituted, some partners leave, some new join, and with that change the business is carried on, then the rights and liabilities, rights and duties, they remain the same as they were immediately before the change. After the expiry of the term in clause B, as we know, we have seen section 7 which deals with partnership at will, which is where no term for the partnership is provided, nor the circumstances when it will determine are provided. That partnership is partnership at will. So at the expiry of the term also, if the business continues, then the rights and duties remain same as these were before the expiry. And this should be consistent with the partnership at will. Third is where additional undertakings are carried out. You know, the partnership can be for particular debenture or undertaking, and with the completion of that, the partnership stands terminated. But in case these are continued and more undertakings or adventures are carried out, then in such case also the rights and duties, they remain the same in respect of, as were in respect of original adventures and undertakings. So that's all. In this video we have discussed the relation of partners with one another in 2 videos, and I hope that you must have understood the details and these will be beneficial for you. At the end, I would request to subscribe to the channel in case you like it. Thank you very much.